All right, so this week we're talking about criminal law, and I'm going to back up for just a second because I don't want to have to stitch those two videos together. But recall that in civil law, which encompasses tort law, we were talking about the duties between citizens to each other. Criminal law, on the other hand, is going to talk about the duties that we have towards society as a whole in our behavior. So it's different from civil law in that way. It's also different from civil law in that the parties are different. The plaintiff in a criminal case is always going to be the government. It could be the state. If it's a violation of state law, it would be the United States government if it's a violation of federal law. Burden of proof is also different in criminal law than it is from civil law. So remember, in civil law, we talked about it being by a preponderance of the evidence. So if you had a tort case, the judge would be deciding whether or not the person was liable for the harm they did by a preponderance of the evidence. More likely than not. That's the 51 to 49% standard. Okay? Not so in criminal law. Criminal law, the burden of proof that the government has to meet to find a defendant guilty is beyond a reasonable doubt. I can promise you that question will be on your quiz. It's not beyond any doubt. It's not beyond a shadow of a doubt. It's not beyond all doubt. It's beyond a reasonable doubt. And that's a lot higher standard than the preponderance of the evidence is. Okay? Beyond a reasonable doubt. Purposes of criminal law and civil law, like tort law, are also different. And I think we talked about this a little bit last week. But the main purpose, you remember, of civil law is to compensate injured people for the harm that was done to them. Criminal law, on the other hand, does have a component of compensation to it, but criminal law is more about punishment. So there's some overlap between the purposes of tort law and criminal law, but the emphasis in criminal law is much more on the punishment part, whereas in civil law, the emphasis is much more on the compensation part. All right. There are also some other purposes of criminal law, and I want to say that I threw this out to y'all and we talked about them. But it's not just punishment, it's deterrence, right? We want to enforce criminal laws because we want to keep people from doing the behavior that's prohibited. If we don't enforce the law, people are going to do it. So deterrence is a big part of it. To a lesser extent, one of the purposes of criminal law is rehabilitation. So some of the folks that get incarcerated for crimes, part of our purpose in doing that is to rehabilitate them so that when they're back out in society that they will not reoffend. And there's also some, like I mentioned, there's a small component of compensation. But for example, let me just give you a scenario to kind of illustrate this a little better. If I punch Khalil in the face and he has to have reconstructive facial surgery, okay? He is pretty concerned with his hospital bill, medical bills, with his missed work, with the money that he may be out as a result of me injuring him. Tort law is going to give him his best remedy. The state of Georgia is more interested in punishing me and deterring others from punching people in the face than it is in compensating Khalil. It's not that the state of Georgia doesn't want him compensated. They do. It's just that their main interest is in punishing the crime, the criminal and the crime. So that's a case where, again, I've told you all this before, but I can't really repeat it enough. The same act or actions or the same set of facts could result in civil liability through tort lawsuits and criminal liability through criminal lawsuits. Okay? I punched him one time, that's one incident, but he could file a civil lawsuit against me for assault and battery, among other things. And the state of Georgia could also arrest me and charge me with assault and battery of the criminal variety. Same act, same incident, two separate lawsuits. Is it possible that I could be found liable in the civil tort case, but not guilty in the criminal case? How's that possible? It is possible. You're right. How so? Different burdens of proof. Thank you, Kenneth. That's right. There may have been enough evidence to make a jury believe that it was more likely than not that I assaulted Khalil. But there may be some facts that would make a jury hesitant to say that I did it beyond a reasonable doubt. All right, classifications of crime. So y'all heard before of felonies and misdemeanors, and there's no bright line for what differentiates a felony from a misdemeanor, but generally speaking, felonies are crimes that are punishable by up to a year or more in prison, and misdemeanors are punishable by up to a year in prison. Misdemeanors are your smaller, more petty crimes, your less serious offenses. Felonies are your more serious offenses. Each state is going to have their own criminal laws, and there'll be some overlap. They'll be similar. I'm sure that the Georgia murder statute is pretty similar to the Alabama murder statute, but they might not be the same. There may be some differences and some nuances that they're not exactly the same. Criminal liability requires a couple different things. It requires a criminal act or omission. The Latin term for that is actus reus. You'll see that in your notes. And then it also requires a criminal intent. So remember in tort law how we talked about, we had a whole spectrum of intent, from intentional torts to negligence, which wasn't intentional, but it was the assuming of a duty that's unreasonable. Okay, that was negligence. All the way down to the other end of the spectrum where you had strict liability. It doesn't matter how careful you were, whether you meant to or not, you were going to be liable in tort. Criminal law has the same kind of spectrum when you're going down and determining criminal intent. So what is the state of mind then? What are the different levels of state of mind that we would evaluate when we're looking at crimes? Well, one is obviously at the highest level is intent. A statute like murder, a crime like murder requires intent. A level lower than that would be recklessness, I would say. Recklessness is a conscious disregard for a substantial and justifiable risk. I might be doing 150 down University Avenue. I didn't intend to kill anybody, but I took a substantial and unjustifiable risk, and that was reckless conduct. And the recklessness might be enough to support the state of mind for a crime. Now, how do we know what state of mind matches up to every crime? It says so in the statute. So I've posted for you some Georgia criminal statutes, and we're going to talk about them Thursday. And you'll see when you go through there, it'll say something like a person commits the offense of assault when he or she intentionally or knowingly. That right there tells you that the required state of mind for that crime is intent. Now, it doesn't mean that if it wasn't intentional, they haven't committed any crime. It just means they haven't committed that crime that requires intent. Like you've heard of manslaughter, right? That is taking the life of another person unjustifiably, but not necessarily with intent to take it. It's a lower form of murder. Okay? If I kill somebody and I didn't mean to, I might not be able to be charged with murder because I don't have the intent or the state of mind to be charged with murder, but that doesn't mean that I can't be charged with a crime. There are lesser crimes that involve taking somebody's life with different levels of intent. So you would always look to the statute to see what level of intent it required. Keeping on going down the spectrum, if we started at intent, then we went down to recklessness, the next level down would probably be criminal negligence. So remember how we had negligence in the civil sense. You can also have negligence in the criminal sense. That would involve the same factors. There'd have to be a standard of care. There'd have to be a breach of that duty of care. It'd have to cause the injury. Person would have had to have suffered damages. So criminal negligence is a deviation from the standard of care that the reasonable person would use under the same circumstances. strict liability, you remember that was the bottom of the spectrum where a person could be held liable in tort for whether they intended the act or not, even if they were not negligent. If they were as careful as they could be, strict liability says you're still liable no matter what. Kind of takes out the whole idea of even needing to have criminal intent. Same thing for criminal law. The bottom of the spectrum would be strict liability. So a good example of that is statutory rape. That is having sex with someone under 18. Doesn't matter if you meant to. Doesn't matter if you were careless or reckless. If you did it, then you can be liable for that crime. Some crimes have strict liability. Just like in tort law, strict liability is not very broadly applied. I mean, that goes against a lot of what we know about being the foundation of our justice system, that you could be held liable for something that you didn't even mean to do, that you were very careful in doing. But there are a few things, a few crimes, a few acts, a few torts that the law has decided it doesn't matter whether you meant to or not. So same thing in this. We go all the way from crimes that require specific intent to do them, all the way down to some crimes that don't require any intent at all. So I know when I was reviewing for today, it does say in your outline strict liability and over-criminalization. I think I probably took out some of the content on over-criminalization, but I think that the point that the outline that content made and that the textbook that this came from made was that there are so many criminal statutes, both federal and state, that there is some belief that we've just gone too far in defining what we say is criminal. So like your outline does say, the federal criminal code lists more than 4,000 criminal offenses and over 10,000 federal rules. Remember, those are from administrative agencies. 10,000 rules, 10,000 pieces of administrative law could involve criminal sanctions. And that's that's a lot. So there's some, I don't really have an opinion on whether I sort of come down on the idea that if society's decided it's wrong, then we need to have a statute or a rule against it. I do think we have way more rules and laws than anybody could ever keep up with, but I don't really have a strong feeling one way or the other. Do y'all? Too many criminal laws, rules, statutes? Anybody think that? No opinion? So that's a good point that Kenneth brings up, and I'll repeat that for my online people, that it is good for our criminal laws, like all laws, but really criminal laws, to be updated with the times. We've got a lot of criminal laws on the books that are over 100 years old, and they need to be updated. That's a legislative process. That means we would need Congress or the state legislatures to review all these and update them. Then we'd have to have some sort of agreement and consensus on how we ought to update them. But your broad point being that they really do need to reflect the times is true. And the example he used is a great one. The marijuana laws. It strikes me as odd, and should strike some of y'all as odd, maybe it does or doesn't, that the same exact thing could be legal in one state and illegal in another state. That is a really weird place we're in right now when it comes to cannabis and marijuana and all that. You could be, in theory, you could be jailed in Georgia, lose your liberty for something that is perfectly acceptable to do in Colorado or Illinois or New York. So that's a good point. All right, flipping over to corporate criminal liability. Corporations can be liable for crimes just like individual people can. That happens because a corporation is made up of humans and people. And if the people who are part of that corporation commit crimes, then the corporation itself can be held liable for that. if any of you have ever been on a board of directors or have an opportunity to be on a board of directors in the future, you need to be very careful about what your liability is for crimes that are committed by employees. I mean, if you're on the board of directors of IBM, it's a ginormous corporation, and the most entry level employee at IBM committed a crime, it's very unlikely that they'd be able to tie that to something that one of the directors should have known. But if the CEO is stealing from the company, or the CEO is covering up evidence that a product was defective or harmful, and the board knew about it, then that intent could be imputed to the board. You have to be very careful. And that really, I can broaden that from board of directors to you are the president of a company. You own your own company and you've got 20 employees. Your liability might depend on what you knew or what you should have known. It's not always going to be a defense to say, I didn't know that employee was doing it, if it was something that reasonably we could say that you should have known. So your liability for crimes could be dependent on your employees. That's definitely something I want to drive home to you. All right, let's look at different types of crimes. So we're going to group them into some different categories. The first one being violent crime. Violent crime is exactly what you would think if I asked for examples: murder, sexual assault, assault and battery, robbery, things that usually involve force or intimidation, violent crimes. You've heard of different degrees of a crime, like you hear first degree murder, second degree murder, third degree murder. That depends on how the state defines each crime. The difference could be things like the level of intent. The difference could be things like the level of pain and suffering that the victim suffered. It could be depend on things like the weapon used. I mean, it's going to depend on how each state defines it. But that is the difference when you hear that degree: first degree child cruelty, second degree child cruelty. The higher the degree, more likely the higher the intent or the worse impact it was on the victim. Property crimes. All right, I'm going to go over some property crimes, and these are going to sound a lot like property torts. Some of them will be not exactly the same, but very, very similar in definition. Burglary. So I always thought burglary was stealing, like burglary and stealing were the kind of synonyms. Burglary actually under criminal law is the breaking and entering the building of another. So I could be the burglar. I'm a burglar if I've broken into Theo's house, even if I don't take anything. It's the breaking and entering that constitutes burglary. I think of the Hamburglar. Y'all don't know the Hamburglar, do you? Kenneth, you remember the Hamburglar? Yeah. He actually took the hamburgers. So that may have been why I grew up confused about burglary. But how do you reconcile burglary versus trespass? They could be the exact same thing. Trespass, remember, is a tort. So that is something that the private citizen who's the victim of the trespass could sue for, whereas the burglary would be prosecuted by the state. Could be the exact same thing. Great question. Larceny. Larceny is what we think of as stealing or petty theft. That's wrongfully or fraudulently taking and carrying away the personal property of another. If I walk over and pick up Mike's phone and run with it, I have committed larceny. Well, that's a good point. So we talk about things in degrees. You've heard of grand larceny. So that would be stealing more valuable things. Grand theft auto, those, that's a bigger larceny than if I take your backpack. Obtaining goods by false pretenses. There are many, many, many forms of fraud. I'm going to throw out a bunch of names of crimes that you're going to hear as that's just another example of fraud. That's obtaining goods by trickery or defrauding somebody out of something. Khalil. Okay. Go ahead. We love off topic. If you steal a crappy car, is it not Grand Theft Auto? It's just Theft Auto. I don't know. That's a good question. I don't know that I've heard Grand Theft Auto in like obviously video games and movies and stuff, but I don't know that I've ever seen a statute or a crime called Grand Theft Auto. I'm sure there is, but I don't know. That's a good question. Receiving stolen goods. Guess what? It is a crime to receive stolen goods, even if you didn't know they were stolen, as long as you should have known they were stolen. So if Patrick comes up to me after class, look, he's smiling because he knows he's, I'm just kidding. And he's like, hey, check out this, this what? iPhone. Yeah, this iPhone. You want to buy it from me. It's obviously not Patrick's. Let's say it has a screensaver picture of some female on it. It looks nothing like Patrick. And it's just obviously not his. If I buy that from him, I may be guilty of receiving stolen goods if the jury thinks that I should have known that it was stolen. Now, let's say Patrick does that for a side hustle. He sells used phones and he has a website and he advertises. And I know that some of you have bought phones from him and I buy a phone from him that's stolen. That looks a lot different because, again, they'd have to prove that I should have known it was stolen. Well, he looks legitimate to me. I mean, a reasonable person would think he's legitimate, I would think, under those circumstances. So, again, it comes down to how we would look at that. Arson, y'all know arson, burning down something willfully, building or some other structure or somebody else's personal property. Forgery is the fraudulent making of a writing, signing a check, signing a contract, signing somebody else's name, or signing some sort of false information in it. Public order crime, those are considered crimes against just the peaceful order of society. That would be like public drunkenness, prostitution, gambling, illegal drug use. They're not really, you don't have a specific victim like you might have in larceny or arson, where I burnt down Columbus State, right? If I'm out hoeing, I might not have any victims, but it might be a crime against the peaceful society or something like that. Hoeing? Huh? It's a public order crime. White collar crime. So we do need to pay close attention to white collar crime because that's the ones that are most associated with the topic of our class. And these are crimes that are committed within the course of a legitimate business operation. White collar crime. Embezzlement. That is the conversion of property or money owned by somebody else, but it was entrusted to a person. So if I work at an auto dealership and somebody brings in a payment in cash and I put the payment in my pocket instead of giving it to the business that I work for, that's embezzlement. Your outline says that even if you intend to give it back, if you kept it in a way that you weren't supposed to, that could be embezzlement. So say if Junior comes to make his car payment to me and I take his cash and I put it in my desk drawer and not in the safe or not in the company's cash register or whatever I'm supposed to do with it, because I'm maybe going to think about what I'm going to do with it. I don't know. And then the next day I decide, I think I better turn Junior's payment in. I could still be guilty of embezzlement up to that point. Or really, even if I kept it for a period of time, that still could be considered embezzlement. If I ended up giving it back, that would, of course, mitigate my punishment. But keeping something that belongs to somebody else in the course of legitimate business is embezzlement. Mail fraud and wire fraud. This has exploded. The wire fraud has exploded. I mean, all of us are victims of wire fraud attempts every day. Anybody look at their junk mail every day like me and clean it out? Every day there's a scam on there that somebody's trying to defraud you. That's wire fraud. Anytime you use an electronic means to defraud somebody, you've committed wire fraud. Used to be that mail fraud was a lot more common than wire fraud. Wire fraud was more telephone back in the day. You still see mail fraud a lot, but wire fraud is just completely taken off with the computer era. I do some work for probate court where if it doesn't have to be an elderly person, but it could be an elderly person, can't manage their property anymore. And by that, I mean their house, their finances, not just their lawn. I mean like their bank accounts and all that. Then it's possible to ask the court to appoint somebody as their conservator to handle their money for them, handle their property for them. Most of the time, that happens within families. Like I might give a power of attorney and let my son have control over my finances once I can't do it anymore. But there are some people that we either don't have a trusted person that can do that, or there's just nobody at all. So in those situations in Georgia, the court can sometimes appoint a third party, a stranger, to do that. And so I don't really do that work anymore, but I used to do that for the probate court where somebody would come in and either their family members weren't trustworthy or they didn't have any and they couldn't manage their money. And so we would do it for them. And often the fact pattern was my granddad is getting scammed. And I mean to tell you, y'all, people that had educated people that had good careers, that had plenty of money, that had a lot of sense, that don't have any problems, they were getting scammed right and left. And there were some people that just had this blind spot for whatever reason, whether it was age or some sort of mental infirmity, where they were believing what they were told. And these scammers are relentless. Y'all, anybody ever had any experience with this or had a family member that's been subject to this? It's bad. And so anyway, that my point being that wire fraud is widespread these days. I even a couple of weeks ago am treasurer for a group of adoption lawyers in the state of Georgia. We have sort of a club, and it's not a very cool one, but we have a club. And I was the treasurer, and we have a website. And I got an email from the president, but it was her name in the email address. I didn't look at the actual address because it just popped up as her name. But she said, I need you to wire this much money to so-and-so for our website design. And we had been having some website design work done. So I was like, okay. And so I emailed her back and I was like, hey, can't remember. I had a question about it. Well, I wasn't emailing her. I was emailing the scammer. And the scammer replied, but then something was off in the reply that made me call her. And I still didn't realize it was a scam, but I was like, hey, you've given me, I think it was 2 different amounts. Like, you gave me 2 different amounts. Which one do you want? And she goes, did you get an email from me asking for something? And I said, yes. She goes, this is the second time this has happened. Check the email address. And it wasn't her work email address. Somebody had created. So they just been fishing online and were like, we'll just send Tebow an email since he's the treasurer from the president and maybe he'll fall for it. And I mean, damn if I didn't fall for it. I mean, I didn't fully fall for it, but I felt pretty stupid. So it's not just people who have mental infirmities or old age now. It's everybody. Or maybe I'm infirm and old or something. Maybe that's the problem. But that's mail and wire fraud. Bribery. Mike, let's say that you're the mayor and I walk up to you and offer you $100,000 to award me a city contract. I'll say I pave roads. And you say, absolutely not. That's illegal and unethical, and I would never do that. And then you report me to law enforcement. Could I get arrested for bribery? How come? The question, right. So the bribery statutes, the crime is the offering of the bribe. So even if he says no, I could still go down for that. Now, if he said yes, then we're both going down. But if he says no, I could still go down for that. Just that offering of the bribe that constitutes the crime. We have this in other ways, as less obvious ways as well, in the form of kickbacks. Hey, Mike, you work for X Corp and I work for Y Corp, and we supply y'all with this part. You keep ordering those parts from me and from our company, and I'll give you $10 for every box that you order. That would be commercial bribery in a sense, kickbacks and the like. The difference in that and a commission being that that's not something you're entitled to. You're going to buy parts one way or another, and your job is to buy them in the best fit, price, and quality for your company, not based on your personal gain, right? All right, Foreign Corrupt Practices Act. There are two parts to this, one less interesting than the other. One is that we can't bribe, it says that American citizens can't bribe foreign officials. So just because there's a German company that's coming to build a plant here in Columbus, if I try to bribe somebody from that company to give me some part of their business, then I can still be guilty of bribery, even though that person is not a U.S. citizen. The second part of the law is something that Trump is in trouble for, which is prohibiting any person from making false statements to accountants or false entries into any records or accounts. So we talked a little bit about the Trump cases. The one that's going to trial this month, supposed to go to trial, is where they paid off the porn star to not give details of their relationship, and then they wrote it off as a campaign expense. So they made a false entry into their ledger about what that expense was. And that's probably the least serious of, not that I condone that, but just on the scale of consequences to Trump, that's probably the least serious of all the things he's been charged with. Bankruptcy fraud. I don't do a chapter on bankruptcy, although I wish we kind of had time for it. But when you go into bankruptcy, it's to be relieved of debt, and you've got to list all of your assets to the bankruptcy court. And if you hide your assets, fail to list them, or maybe I give Jaden, I sign him over some of my assets while I'm going through bankruptcy, and then he's going to sign them right back over when we're done, that would be bankruptcy fraud. Theft of trade secrets. Who's in the best position to steal a trade secret? Yeah, employees, right? See, yeah, employees are. Is that what you said? What'd you say, Patrick? Junior, what'd you say? Politicians. Oh, yeah. I mean, they do get made aware of a lot of things going on, and administrative agencies who are approving drugs, they're seeing the formulas and they're seeing things that are marketable that they could steal. So yeah, that actually is a very good answer. So you can't steal, proprietary information for your employer, formulas, mailing lists, algorithms, things that the employer has developed that are unique to them. Insider trading. So this is an important one. It's very hard to prove, in my opinion. You don't see it prosecuted a ton, but you do see it sometimes. This is what Martha Stewart went to prison for. I think Phil Mickelson was accused of this, but I don't think he ended up having any criminal liability for it. Nancy Pelosi? I don't think she got. I gotcha. So politicians and insider trading is a really sticky area. Insider trading is just when you have information that's not public, that the public doesn't have, and you buy or sell stock in publicly traded companies based on that inside or non-public information, that's a crime. So you guys have all taken, I know by now in your college career in the business school, you know that the whole stock market is based on the idea of equal information, that everybody has equal information. And if we don't have that going on, then we've got some inequities and it's an unfair market. And the examples of insider trading that come down that are most common are usually, let's say I am CEO of a drug company and I find out that we've got a major problem with one of our drugs causing cancer. It's not public yet, but I decide that I better unload a whole bunch of my stock before it becomes public so I can cash it out, before the value goes down. Insider trading. I tell my wife, hey, you need to sell your stock in my company. I tell my mother, my cousin, hey, y'all better sell your stock in my company. We've got an announcement coming out in a couple of months that's going to make value go lower. Insider trading. You don't even have to know the person. I could be sitting at the Little League field and overhear the CEO of Aflac sitting on the bleacher behind me talking about some news that's not public that would affect Aflac's stock price. If I act on that, I'm guilty of insider trading. That's why I say it's hard to prove. The connection between, somebody would have to make the connection between me overhearing a phone call at a Little League game. That's really not likely to happen unless somebody's got us wired and mic'd up and cameras on us the whole time. That'd be very difficult. I think it's not as difficult when you don't have a good reason, like, hey, John, you sold $3 million worth of Merck last week. And it just so happened that it came out that all their drugs cause cancer this week. How do you explain that? The government still has to prove it's a crime. They've still got to prove beyond a reasonable doubt that you did that. So they've got the circumstances. That was funny timing, but they've still got to show that John knew about it ahead of time and acted on it. So that's why I say I think it's sometimes hard to prove. I had another point to make on insider trading, but I've forgotten what it is. Yeah, I can't remember. That's been a while. Martha Stewart. I think in Martha Stewart's case, somebody pled guilty to tipping off people, friends, investors. And so then they had him because then they had somebody saying, well, yeah, I called John last week and I told him that he better sell his stock. That's some direct evidence that would be a lot easier to prove. I know what I was going to say. When COVID first hit and the senators were being briefed on COVID matters and vaccine matters and all that kind of stuff, and then Kelly Loeffler, who was our senator from Georgia at the time, sold a bunch of, or either sold or bought, I can't remember which way it was, but she got accused of insider trading, that she had traded based on knowledge that she gained privately in that Senate briefing. She wasn't ever charged with the crime. I think there was like an ethics complaint against her, and she didn't end up taking the fall for it. I think her defense was that when she got appointed to the Senate, she put her stock and all her stock portfolio and investment accounts with what we'd call a blind trust. In other words, like that somebody else was doing the trading for her. And if you're going to be a politician or a public figure, that's the first thing I would do, because inevitably you could get accused of that. And if you could show, well, as soon as I got elected or appointed, I gave up all control of my stock portfolio to somebody else. Now, we don't know that she didn't call up and be like, hey, I'm going to sell that stock. We don't know that, but that is a good safety thing that she did put in place. So I don't know. I don't have any opinion one way or another on her guilt on that. So those are the white collar crimes that I want y'all to know about. And remember, the ones we've talked to up till now, have been crimes that are committed in the legitimate course of business. So I want to switch gears now to crimes that are committed in illegitimate businesses, racketeering, mafia, those types of crimes, where the business itself is a criminal enterprise. The business is crime. In insider trading or in embezzlement, those were examples of legitimate businesses that the crimes occurred within. We're now going to flip over and talk about organizations where their whole purpose is a criminal enterprise. Money laundering, that is a form of organized crime. So it's illegal to take money from a legitimate business enterprise. No, I'm sorry, I got that backwards. It's illegal to take money from an illegitimate business enterprise and run it through a legitimate business. So an example of that is, let's say that I put a shakedown on all the businesses on my block downtown where my office is, and I charge them $1,000 a month for protection from my gang or whatever it is that I do. And I also have a sandwich shop, and I take all the money that I get paid from my threats and all, and my I'm not giving it the right name, but I take all the money that I get paid illegally and I deposit that in my cash register at my sandwich shop. So then that becomes money that I've made in a legitimate way from selling sandwiches. That's money laundering. You're, in a sense, cleaning the money by taking it from an illegitimate enterprise and running it through a legitimate enterprise. That is illegal. Racketeering. So it became, or it was hard to prosecute the mob at one time, and it still is in a lot of ways. It was hard to prosecute the mob because when you run a criminal business enterprise, there are a lot of little criminal things going on everywhere. But you're not necessarily going to be able to connect them all. You're very rarely going to find evidence that, hey, yes, I'm the president of this criminal enterprise. I've directed all of this. This is how it all works. I mean, the mob is very secretive and all that. One person does something, but they don't know how that affects up the chain. They're just doing their job and doing what they're told. So it's hard to connect all those pieces into a larger picture. So we wrote statutes called racketeering statutes. You hear this called RICO all the time. That's the acronym for that, RICO. RICO has a list of smaller crimes that if the government can prove you did 2 or more of them, then they can build that up into a bigger crime. So it might be 2 little things, like petty theft or something. But if they can prove that I'm doing 2 or 3 of them, then they can tie those together as that's my business of crime, so to speak. When they might not really have anything to do with each other individually. They might be less serious in and of themselves, but combined they can get together and say, okay, you have a pattern of criminal activity. All this is interrelated somehow. That's racketeering. So the racketeering statute in Georgia is what Fulton County has charged Trump with, violating the racketeering statute. Now, it was written for to prosecute mob activity. Nobody is seriously saying that whatever happened with the election interference was a mob activity, but they're taking a law that was meant to apply to racketeering and they're applying it in a non-racketeering context. So that's how they were able to sort of build a more serious case against Trump, and also not just against him, but when you can tie people together, you can go after more people. So there were like 18 or 20 co-defendants or something, but the theory behind the prosecution was that they were all conspiring together to unlawfully interfere with or overturn the election. What so-and-so did down in Coffee County that arm might not have known what the other arm was doing up here in Fulton County, but it was all part of the same criminal enterprise and idea. That's the theory behind that prosecution. Cybercrime, we could probably do a whole class on cybercrime. I think you guys, anybody here in management information systems, don't y'all do it? Isn't there a whole class on cybercrime? Or am I wrong about that? Nobody's in that. We all what majors are y'all? Who else management major? Couple. What about marketing? What am I missing? Is there general business? Oh yeah, accounting. Anybody have a major different than one we've named? Finance. Anybody in computers science or anything on the computer side? All right. Anyway, I was just curious on that. So, I mean, cybercrimes are a humongous category. They are evolving, Kenneth. That is one. They're probably not keeping up with technology, but that is something that we didn't have any laws on the books 20 years ago, probably, on cybercrime, or not much, and now we do. But basically, that's any crime that's committed through the internet. All right, just like we had in tort law, we had defenses to criminal liability. We have defenses to civil liability and tort liability. We have defenses in criminal law as well. So let's talk through a couple of those. I'm going to finish that, and then Thursday we'll go through some of the constitutional protections, like Fifth Amendment protections and Fourth Amendment protections against unreasonable searches and seizures, that kind of thing. We'll do some of that on Thursday. But I want to cover defenses for the rest of the class time we've got today. So, one defense to a crime. And again, when you think about defenses, remember I told you at the beginning of class that in order to be liable for a crime, you've got to have the guilty act and you've got to have the state of mind that the statute prescribes. So these defenses are going to negate one of those things. The defense might negate the act or it might negate the state of mind. First one is justification. If a burglar breaks into my house and pulls a gun on me and my family tonight, and I shoot the person and kill him, did I intend to shoot him and kill him? Hell yeah, I did. All right? That sounds a lot like murder, doesn't it? No, because, well, I want you to look at it two different ways. Did I do the criminal act? Did I intend to? All right. So I've met those things, but I have a defense to those over here that may negate that. My defense could be justification, self-defense, justifiable use of force. That would be a defense to that crime. It's not a defense to every crime, and it's not a defense to, it's not a blanket defense. Let's say that John broke into my house with a slingshot, and I turn an automatic rifle on him, and I'm charged with murder or some sort of manslaughter or something, and my defense is justification. Was I justified in using my AK against him? Depends on who you ask, right? It depends on the circumstances. I'm not trying to be flip and funny about it. A lot of it has to do with the state of mind of what I reasonably believe the threat was. If a child breaks into my house or wanders into my house and calls me a name and I blow the child away, it's not, the jury is not going to think that I responded in a reasonable way to the threat. Most states say that the response has to be commensurate with the threat, that there has to be a relation between the threat and the response. That differs from if you're talking about like maybe just if I were to get in a bar fight with somebody coming into my home. They're different. The law recognizes some differences in your right to defend your home and your residence and your privacy. But the discussion question for this week does involve a relatively new Florida self-defense statute that has to do with using deadly force on home invasion. So make sure that y'all look at that and give me your opinion of that Florida statute at some point. All right, justifiable use of force. The next one would be necessity. If a criminal act is necessary to prevent an even greater harm. Let's say that a school shooter comes in through that door and is getting ready to open fire on class, and I take him out. Okay, I could probably also use justification, self-defense as a defense, but I also might use necessity as well. It was necessary for me to kill him to prevent him from killing a bunch of innocent people. I might be walking down the street and I see that there's a fire inside this store that's closed for the night. I find a brick and I break in through the window and go in there and put out the fire. Have I probably committed burglary? Yeah, right. I meant to break in. I did it on purpose, but I had a justification for it. It was necessity. That might be a defense that I could use. So when we think about, I'm going to give y'all on Thursday some fact pattern scenarios like we did with torts, and we're going to think about whether or not there's a crime there, but also whether there might be a defense available to the person. Insanity. Y'all have heard of that. A person who suffers from a mental illness might be incapable of the state of mind that's required to commit a crime. So remember, talked again at the beginning of class, criminal liability, you got to have the guilty act and the guilty state of mind. Well, if I'm completely incapable of having that state of mind, that might be a defense. I'm not able to appreciate that my actions are right or wrong. Maybe I'm having a psychotic break, or I have a developmental disability that makes me unable to understand what is right and what is wrong. Those are defenses that I could use. Now, it's not one that you can just go in there and throw around. You'd have to have some evidence to support it. You'd have to have some psychological evaluations. You'd have to have some experts come in and say, I don't think this person has the capacity to understand what he did. Mistake. So this is an interesting one. Mistake of fact, that sometimes could be a defense. Not always. And I'm going to give you some examples. This is kind of confusing. Mistake of fact can sometimes be a defense if it negated the criminal intent. But mistake of law is never a defense. So I get pulled over for going 80 on University Avenue. I thought that the speed limit was 80. That is not a valid defense. I bought cocaine on the street corner. I thought cocaine was legal in Georgia. Not a valid defense. That's a mistake of law. That doesn't work. Mistake of fact sometimes maybe. Mistake of fact is harder to think of examples of, but I go to a bake sale and I buy some pot brownies from this table, and this person is selling them, but I didn't know that. I thought they were regular brownies. It was a bake sale. I had no reason to know that person was selling marijuana brownies. That might be a mistake of fact to the charge of possession. Again, it's going to be, based on the set of facts, is it reasonable that I should or shouldn't have known? Kind of like some of the other things we talked about today. Do you have a question? All right. So mistake of fact sometimes could be a defense. Duress is a defense that involves somebody doing something wrong because they were pressured into it. They did something that they otherwise would not have done except for the pressure they were under. Khalil holds a gun to my head and says, "You will take out your phone and you will log on to your wife's bank account and you will transfer me $10,000 or I'll shoot you. I have taken money from her. Probably a bunch of different crimes we've talked about today that I committed, but I did it because I was under duress. There was a threat to me. There has to be a reasonable belief in the immediate danger. Okay, the belief that I was in danger has to be reasonable. If Khalil has a Glock pointed to my head and I know what it is, it's clearly a real gun, that's a reasonable belief that I'm in danger. Okay, if he comes in here with a squirt gun, a water gun, and points it at me and says, you need to get on your wife's account and transfer me $10,000, is duress going to be a good defense for me? Probably not, because is it reasonable for me to think that that was a threat? No, unless Khalil's got some skills with a water gun that we don't know about. He could, I suppose. So that's duress. Entrapment, that happens when a police officer gets the criminal to commit the crime. Okay, to make them do something that they weren't already going to do. So let's say that I'm walking down the hall and there's an undercover policeman and he comes to my office during office hours and it's like, hey, you want to buy this cocaine? And I'm like, no, I don't think so. We're at school. Also, it's illegal. And he's like, man, come on, I'll make you a deal on it. And I'm like, no, I don't. No, thank you. He's like, it's $100. I give it to you for 10. Like, and they just keep on and keep on and keep on. And finally, I give in. I could use the defense of entrapment. But the key would be, did he push me, twist my arm into doing something that I wasn't already going to do? If I go down to a part of town where it's well known that that's where you got to go to buy cocaine, and I'm down there, and that's why I went down there, and there's a police officer who walks up to me and was like, hey, I got some cocaine, you want it? And I'm like, I don't know. And he keeps talking to me, and finally he's like, I give it to you for $1, and I'll buy it. He did kind of push me into it, but that's what I was down there to do. He didn't get me to do something that I wasn't already going to do. So entrapment would not be a good defense for me in that case. Well, that's a great point, John. The question is, how are they going to know what you were down there to do? They're going to have to prove it, right? The plaintiff has the burden of proof. And if this is a crime, they're going to have to prove that it beyond a reasonable doubt to convince that jury that I was down there to buy cocaine. Maybe if they don't have any witnesses that I told that's what I was going to do, maybe they've got people down there that have testified that I come down there every Friday to buy cocaine from them. Maybe maybe there's some other circumstantial evidence like that, but then they're going to have to prove it. It would be, if they didn't have direct evidence, it would be a little harder. I would also, I take that back. I was about to say I'd have to come up with a good reason of why I was down there, but would I? Would I ever have to tell the court why I was down there? Right, and what else do we have? What other protection do we have that we're going to talk about Thursday? The right to not incriminate yourself. So they could not force me to say what I was doing down there. But if they could somehow establish a pattern that I'm always down there buying cocaine, that'd be a problem for me. But again, a lot of times why you see people either not charged with a crime or charged with a lower crime is because the government doesn't think that they can prove in court that you did it. It might be obvious that I did it, but they might not be able to have the evidence to prove beyond a reasonable doubt that I did it. So that they therefore won't charge me, or they'll charge me for a lesser offense that they do feel like they can prove. A lot of the times the charges depend on what the government thinks they'll be able to prove. So one more defense, statute of limitations. Y'all ever heard of that? There are laws on the books that say that after a certain amount of time has passed, you can't be charged with X crime. It's not a blanket, it's not a one time period that applies to all crimes. It's different. It's different by the crime, and not all crimes have statute of limitations. For example, murder, there's no statute of limitations on that. I could murder somebody 100 years ago if I'm still living, and they could charge me with it 100 years later. But there's some other things like assault or public drunkenness or some lesser crimes that they might try to charge them with 30 years later, and I could use statute of limitations as a defense. There's a law that says if you're going to charge me with this crime, you got to do it in this certain amount of time or else it's too bad. I get off free. All right, those are defenses. So Thursday, we're going to talk about constitutional protections. We're going to go through some fact scenarios like we did with the convenience store guys, and we're going to talk about the Carpenter versus U.S. case. Please make sure you read that case. That involves the use of police getting cell phone location data from the cell phone company to track where you've been without a warrant. And so this is a Supreme Court case that talked about whether or not the police should have had to have gotten a warrant before they got that location data information from the cell phone company. So we'll definitely talk about that on Thursday, and I will definitely be calling on you like I usually do. All right, see y'all Thursday.